Leon Curtis was the general manager logistics at Optus, and Craig Hasler was his offsider. They worked out a way to make a lot of money from Optus. They created, on the side, a warehousing company, which Hasler then went to operate. Curtis made sure that Optus gave big contracts to that warehousing company at a huge markup. Obviously, this was extremely dodgy. On an action for breach of fiduciary duty, it was alleged that Hasler, the offsider, was also liable to Optus. But unlike Curtis, Hasler didn't have a fiduciary duty. He was merely an employee. It was argued that he was liable anyway due to a case called Barnes and Addy, which said that a third party could be liable if they assisted with knowledge in a dishonest and fraudulent design on the part of the trustees. Here's where it gets complicated. The High Court, in a case called Farrer Constructions, had given an interpretation of the meaning of dishonest and fraudulent in Barnes and Addy. The Western Australian Court of Appeal had then given its interpretation of Farrer Constructions, in a case called Westpac and Bell. The New South Wales Court of Appeal was now being asked to follow Westpac and Bell, which was narrower than the other two. Now, if the Western Australian Court had been interpreting a statute, and New South Wales had an identical statute, then we would expect New South Wales to follow the Western Australian precedent. But in this case, the law did not come from a statute at all. It started in the English Chancery Court, which was interpreted in the High Court, which was interpreted in the Western Australian Court. The court in New South Wales found that it could not be bound in such circumstances. Justice of Appeal Leeming called on the writings of the famous positivist HLA Hart, who said in The Concept of Law, "Unlike an authoritative text or statute book, judgments may not be couched in general terms, and their use as authoritative guides to the rules depends on a somewhat shaky inference from particular decisions, and the reliability of this must fluctuate with the skill of the interpreter and the consistency of the judges." It followed from this that the authority in Australia was the High Court judgment itself, and not a lower court's interpretation of that judgment, and the court reached this opinion by relying, at least in part, on theories of jurisprudence.